Hi, my name is Annette Ibarra, and today I will be talking about private placement memorandum, due diligence, term sheet, and their regulations. Growing companies may choose to gain capital through a private placement offering. The company should prepare a private placement memorandum, or PPM. The PPM should give a background about the business, discuss the terms of the offering, and disclose the benefits and risks associated with the investment. Financial documents may also be attached. A private placement offering is a sale of securities to limited investors. The sale is not open or advertised to the public. A private placement is used to raise capital. A company may choose to go with a private placement versus a public offering because the company wants to stay private. They also get to choose their investors. For a growing company, a PPO may be the better option because it is more cost efficient than a public offering. You do not need an underwriter or broker with the PPO. It is also not required to file with the SEC, which can cut down on some of the fees. Regulation D under SEC makes a PPO exempt from filing with SEC as long as certain requirements are met. Rule 504 states a company does not have to file the sale of securities if the company offers and sells a max of 1 million of their securities within a 12-month period. Rule 505 states a company has a max of 5 million in a 12-month period of offers and sales of securities sell to accredited investors or a max of 35 other individuals. The sale of securities is restricted and advertising was not used for the sale of the securities. Rule 506 is similar to Rule 505, however, the 35 individuals that choose to buy the securities must be educated in the benefits and risks of the investment. A company that meets the requirements must still file Form D with SEC. Form D is a basic form that states company owners and stock promoters. The PPM must state why the offer meets the requirements under Regulation D and shows the investors that the company is complying with SEC. Section 4.2 exempts certain transactions from having to file with SEC. There has to be no advertising, the number of investors is limited, and should usually be individuals currently involved with the company. Section 3A1 states filing with SEC is not required if the securities being offered is not crossing states. A PPM should list all possible risks associated with the investment. By doing this, the company offering the sale protects themselves from liability in case the company declines or goes bankrupt. Risks listed in the PPM should be specific to the company and not listed as general risks that can occur in just about any other company. The PPM should be as accurate as possible. By providing full disclosure and being transparent in the PPM, investors are fully informed regarding any possible risk, making it hard for them to hold the company liable for any loss. There are disadvantages of PPO. It may be hard to find investors, and investors that are found may not be willing to invest the amount that you want. Securities are usually sold at discount, and at times more securities have to be offered in order to secure investors. Investors should exercise a standard of care when investing. This is done by due diligence. Due diligence is an investigation or audit of a potential investment. By doing research on any potential investment, it allows investors to make an informed decision on whether to invest or not. Investors shouldn't take what is being told at face value, but conduct their own investigation of the company. Due diligence can reveal information that can help decide if an investor should go ahead with an investment. Due diligence can be performed by various individuals such as an accountant or attorney. A third party may also be used. Due diligence should be conducted before any contracts are signed. Any relevant information to the investment should be gathered. It is important to remember that too much information can be a hindrance and not useful because it all needs to be analyzed. The company making the offer should look into their investors to make sure they meet the needs of the company. Investors should investigate the company because it is their money that could be lost in the investment. A term sheet outlines the terms or conditions of the offer being made. In most cases, it is not a binding contract. The term sheet is usually direct and lists all terms regarding the offer. There are several aspects to a term sheet. Some of the key areas are the issuer. It should clearly state on the term sheet who is issuing the securities. The details of the investment should be stated, such as price per share and how many securities are being issued. Investors are going to want to know what rights they are being given in exchange for their capital. They may want voting rights or rights to consent. The board of directors is also included in the term sheet. This will show potential investors how the board is made up and their investment is being managed. The exit is the terms of duration for the investment. Closing is the terms that have to be met before any contracts are signed, such as performing due diligence, and following any state or federal laws. Investors may have only a certain amount of time before the offer expires. The time limit should be clearly stated on the term sheet so investors have adequate time to conduct due diligence.